Reserve 5 minutes, sir?
Yes, Your Honor.
Okay.
May it please the court, my name is Felix Montanez and I represent the appellants in this case, Advanta IRA Services. This is an appeal from an order granting a motion for summary judgment in favor of the appellee. The original action was an interpleader action filed by a title company against my client, Advanta IRA Services, and the appellee, FTE Properties LLC. Both parties claim to be entitled to a portion of the sale proceeds. The underlying
So, sir, it seems like your big issue is there was some work done that was not memorialized by these promissory notes, which your client lent money on, and then there's a question about how interest was calculated. Are those two of the main issues?
Yes, Your Honor. I would say those are the two issues. One, is my client entitled to sums that were not reflected in the promissory notes? My client believes that they are, and I believe the record establishes that they are. And how long would interest accrue on the promissory notes?
So the trial court made a determination at a summary judgment level that there wasn't evidence or sufficient evidence to award your client these unmemorialized sums, and found that there were no disputed issues of material fact with regard to that issue, correct? Isn't that what the trial court found?
That's correct, Your Honor.
Okay.
Yes.
Summarize for me the summary judgment evidence that the court had in front of it on this issue.
Yes, Your Honor. The Advanta IRA filed a verified answer to the petition for interpleader, which raised 3 affirmative defenses. The first was that they had a superior claim to the property and specifically alleged that sums were loaned in addition to the amounts that were reflected in the promissory notes. The second affirmative defense is that the defendant, the opposing party, the appellee in this case, filed a fraudulent claim of lien on the subject property and had unclean hands. And the third affirmative defense Advanta IRA raised was that at all material times it negotiated in good faith. Advanta also submitted an affidavit in response to the motion for summary judgment, which set out with specificity the amounts due on the promissory notes and the interest that would be due at different times, whether the court wanted to use the date of closing on the subject property, whether the court wanted to do the date at which the interpleader was filed, or if the court wanted interest.
Well, there seemed to have been a big issue that your client was the cause of the delay of all these things. And it seems like the court didn't think your client should benefit by accruing interest after it was your client who could never give an escrow, an estoppel letter or payment letter. This is what we're owed, so interest could be calculated, right?
Yes.
Isn't that kind of what the court said? It's your fault. We're not going to reward you for this delay that you've created.
Yes, Your Honor. That is what the court held, and we believe that there was material issues of fact regarding that. That there wasn't sufficient evidence before the court to establish conclusively whether my clients were the cause for the delay.
But your clients had to issue the estoppel letter, I call it, and presumptively they know what they're owed. They know what interest is being calculated. And when you ask a lender, I want to make a payoff, give me an estoppel letter, that letter should come very quickly. And if a lender is going to delay issuing that letter, it's really hard to reward that lender for accruing interest during the period of delay. So it seems like a fairly simple thing to me your client could have done but didn't do. And I guess the court was persuaded that by the judgment evidence in front of the court at that time that your client wasn't entitled to this additional interest.
Your Honor, the issue why a payoff couldn't be submitted is because there was a disagreement as to whether the additional sums that were not reflected in the promissory notes, whether those sums were due.
Well, your client, go ahead, Judge Lucas.
I'm sure I'm probably going to say exactly what you were going to say, which is that has absolutely nothing to do with the ability to issue an estoppel letter. I mean, you don't have to come to terms on an estoppel letter. The purpose of the estoppel letter is, in fact, estoppel letters are all the more needed when you have a dispute, because then you know exactly, hey, this is the line in the sand that we're drawing. This is what we claim we're owed. So I'm having a hard time understanding what the summary judgment importance of the fact that there was a dispute about amounts owed had anything to do with the failure to issue an estoppel letter.
And from my client's place, they were negotiating a payoff, and my clients allege in the summary judgment evidence that it was actually the appellee that broke off those negotiations. So there were talks about what amount was owed. No, a formal payoff was not produced because there was a clear disagreement between the parties.
A payoff letter, an estoppel letter, and that's what seems to be a missing piece here, and that it is a little troubling, and it certainly apparently troubled the trial court, and I think it's kind of understandable why, right? I mean, that helps crystallize the position. You know, you put down to the dollar and penny what you claim you're owed, and then the borrower can come back and say, no, that you've inflated it. There's items in here that didn't get done. You computed your interest wrong, or whatever, and then you have a discussion. But not providing the estoppel letter, I don't know how you get past that.
Yes, I understand. And even if the date of closing is used as the date at which interest stopped accruing, if you add the amount of principal and interest that were due at that date to the amounts that were loaned that were not reflected in promissory notes, those amounts are in excess of the amounts that were being held in this case. So we believe that in either way, no matter what date you use to calculate interest, my client was entitled to all the proceeds from the sale. We believe that my client's affidavits established a genuine issue of material fact regarding whether my client had loaned the appellee additional sums, and also created a material fact as to whether my client acted in good faith. I'm reading from Volusia County versus Aberdeen at Ormond Beach. It says summary judgment is only appropriate if there is no genuine issue of material fact, and if the moving party is entitled to judgment as a matter of law. And the burden of proving the absence of a general material fact is on the moving party. And generally, courts are required to draw every possible inference in favor of the party against whom summary judgment is sought. Advanta IRA, my client filed a verified answer and affirmative defenses, and they filed an affidavit alleging that Advanta IRA had loaned the appellee additional sums to improve the property. And the answer and affirmative defenses also alleged that Advanta IRA had acted in good faith to negotiate the payoff. And in fact, it was the appellee that broke off negotiations in that regard. I believe that both of those documents alone establish that there was a genuine issue of material fact in this case regarding whether additional sums were loaned that in addition to the promissory notes. And your honors, even if my client had not submitted any of those affidavits, the appellee had failed to refute the appellant's affirmative defenses. So summary judgment should not have been entered as a matter of law. Until a moving party in a motion for summary judgment has successfully met its burden to show that there is no genuine issue of material fact, the opposing party is no under obligation to show that issues remain to be tried. And before the moving party in regards to a motion for summary judgment may be successful, they must either factually refute all the affirmative defenses raised or establish that they are legally insufficient as a matter of law. That language is from Frost v. Regions Bank, which is out of the 4th DCA. There's also, a court cannot grant summary judgment where a defendant asserts legally sufficient affirmative defenses that have not been rebutted. That is from Haven Federal Savings and Loan Association v. Curian. That is a Supreme Court of Florida case. In this case, Advanta IRA raised in their affirmative defenses that they had loaned the appellee additional sums outside of the promissory notes that were owed. The appellee never rebutted this claim. The appellee never even bothered to deny that those additional funds had been lent. So we believe that the lower court committed an error in granting a motion for summary judgment, even if the affidavits that the appellant filed are disregarded. Furthermore, we don't believe that the final judgment of the lower court is supported by the summary judgment evidence. There's certain statements in the judgment that are not supported by the summary judgment evidence. The court alleged that Advanta had dragged its feet on getting this resolved, that Advanta was a sophisticated party with who was familiar with funding house renovations, and that Advanta caused excessive delay and it is not fair for it to benefit from the earning increased interest. I don't believe any of those statements are supported by the summary judgment evidence. And it appears that the court took unverified statements from counsel for the appellee at the motion for summary judgment hearing and accepted them as fact. Furthermore, the only summary judgment evidence that was provided on the amounts due on the promissory notes was provided by my client, and those figures, even if you use the date of closing, the amount of the judgment does not match up for that. For example, the trial court entered a judgment awarding my client $121,590. When you take the only calculation that was in the summary judgment evidence of the amounts due, my client would actually be entitled to $126,298.53. So for all those reasons, we believe that the lower court was in error, and we would ask that the court reverse the lower court's decision and remand this case for further proceedings. Thank you.
Thank you. Ms. Newell, you're back?
Yes, Judge Morris.
All righty. So go ahead whenever you're ready.
May it please the court, Erin Newell for representing the appellee, FTE Properties. As this panel has pointed out, the two issues were really regarding the appellant Advanta's entitlement to additional monies. It said it loaned, but could not prove. And the second issue was how long was this interest accruing and how much interest should have been.
So if we could focus on these amounts that were not memorialized by the promissory note. I mean, this is summary judgment stage. It appears that this is a disputed issue of certainly a material fact. So for the court to resolve this issue at this stage would be a little bit unusual. So walk me through what you think supports the court's decision to find this is not a disputed issue of material fact.
Yes, Your Honor. And I'm going to specifically speak to those undocumented additional monies that were reportedly loaned.
Yeah, that's the issue I'm focused on.
Correct. The court, during the first summary judgment hearing, which there is no transcript of, the court actually said, look, you're not giving me any evidence of what you're saying they owe you. And this is a failure, an inability to prove. That's the precise language that's used in the ultimate final order. So the court actually found there was no substance, in fact, that precluded summary judgment at that time. The court gave the appellant additional time, 10 additional days to come forward with documentary evidence that could show those monies were lent. And that opportunity was taken by the appellant. However, the documents that were produced, and this panel asked the appellant's counsel today, can you summarize how that documentary evidence proved these undocumented loans? Counsel did not answer that question today. The court found that these documents, there was no evidence that they were related. And if the court will bear with me, I will read directly from the final order because the court's rulings are very specific in this regard. It is not sufficient to rely on the documents attached to its affidavit because it had no duty to make repairs to the house. There is no credible proof that the receipts and invoices relate to the joint venture, as opposed to, for example, a personal home or that services were even performed.
And that sounds like the kind of finding that, with the benefit of having taken testimony and having weighed credibility, that a finder of fact could certainly make. But it seems like the trial judge here was kind of maybe putting on the proverbial green eye shade and saying, well, I don't, yeah, you've handed me these receipts, you've handed me these statements, but I don't think they really go to this project. Was that really a proper view of the evidence in light of the summary judgment standard?
Yes, Your Honor, it was a proper view because the summary judgment standard, subsection C of Rule 1.510, requires evidence to be submitted in an admissible form. It's a proper objection or a proper observation if
Well,
there's
isn't that a separate question? The question of whether the trial court, if the evidence had been in admissible form, was weighed by the court in derogation of what should have been the proper summary judgment analysis? Isn't that a separate question?
Yes, Judge Atkinson, and that's my point. The argument was made below by trial counsel that these were not substantiated. They couldn't actually be submitted into evidence. And it's our position that these rulings that were made in this order are in response to that exact argument.
Well, help me out. What is the evidentiary what is precisely the evidentiary objection here?
It is stated in the record, but I will paraphrase from the transcript of the hearing. Essentially, trial counsel said that there was no way to verify.
What is that? What is the, how would that make, you can't verify it. Okay, well, that's why we have trials, is to get to the bottom of whether or not something has veracity to it. I mean, is that an authentication objection? What is it? Hearsay? What?
And Your Honor, you are correct. There are different contexts in which you can look at that inquiry, but this was in terms of an authentication. There was essentially a document.
But that's not what that's not where the trial judge landed, right? And this goes to Judge Atkinson's point, which is that those are two discrete analyses. Is it admissible? And if it is admissible, then you get into the, well, is it credible or not, which the latter really it shouldn't be a feature in a summary judgment hearing. And it seems like the trial judge's ruling here is not that it was inauthentic and hence inadmissible and can be considered, but rather more along the line of, is you just came up with some documents. I just don't think they'll carry the day for you.
And I believe I see what the court is really looking at. I mean, there is the phrase, no credible proof that the receipts and
you hit it right on the head there. That's my problem, is that credibility is not something to be determined in summary judgment.
And Your Honor, really, the court's oral rulings clarify what the scope of this written finding is. The arguments that were made below were not about the credibility of the affiant. They were not about the credibility of the papers that were submitted. The arguments that were made before the court and the findings that the court was making, as reflected by the transcript, are that there's simply no way to tell what the authenticity and relation of these documents were. Moreover, again, the court, this was actually the second shot that the court had given. The court specifically states on the record during the hearing, asked trial counsel for Advanta, but where are your bank statements? Where are actual traceable funds that show that these monies were taken out? And trial counsel conceded at that point in time, they could not come forward with that evidence. So regardless of this language that could be interpreted as making a credibility finding, so it's clear on the record that it was not a credibility finding. Regardless, the fact of the matter is the appellant was unable to prove this claim that it stated in its affirmative defense. And that is a proper basis to grant summary judgment, where it's clear that claims that are being made are incapable of proof. There's no necessity to go forward to a judgment and to draw on the litigation. It would also point out that this is an interpleader. So the proceedings are a little bit different. The fact that we have two interpleader defendants, both claiming an interest, and really, quite frankly, there was no dispute as to the first affirmative defense that there is a superior interest in the lien by the creditor, who is Advanta. That was conceded very early on. The issue became, they won't tell us what we owe them. We've asked for a payment letter and estoppel letter, as the panel has pointed out. And quite frankly, on this second issue, it's very clear there is unrebutted affidavit testimony from the affiant that they did not issue an estoppel letter. The countervailing affidavit, which we do challenge, and we challenged below whether that could even qualify as evidence under the standard subsection C, because there was a lack of allegation showing that there was an actual knowledge of what was going on by the affiant, Gillespie, excuse me. But even if we assume that that was admissible and that affidavit could be considered summary judgment evidence, there's absolutely no testimony in that affidavit, no averments whatsoever, that dispute that there was not an estoppel letter issued. And quite frankly, the counsel for the appellant misstates the record somewhat when he says that the affiant tried to explain that. There's no explanation. There's just a bald statement of fact that they operated in good faith. Didn't say, well, the reason we didn't issue an estoppel letter is because we were operating, we were led astray, the other side threw us off the path. None of that. None of those explanations were provided. So quite frankly, the unrebutted testimony in the record is, as this court found, that there was no estoppel letter issued. And that also goes to the fact that even in the pleadings themselves, Advanta would not identify which level of interest it was charging. It gave 3 alternative options. So quite frankly, there was never even a prayer for a specific rate, not rate of interest, but time that interest was to accrue to. So the court did look at the judgment, look at the evidence on file, which was the pleading. In the pleading, Advanta stated that the principal was 105, excuse me, let me double check, I'm sorry. 103, I believe, 103,500, I believe was the exact amount that was alleged by the appellant to have been the figure that was due on the principal. And then it took the interest that the appellant had suggested and added that. And together that rendered the award of 121,590. Now it is true that it appears that 13 cents were actually omitted from the court's final figure that it was releasing to Advanta. Once again, we would point out that there's a specific procedure in the rules that would allow Advanta to actually address that judicial error, the rule 1.530G. That motion was not made. So it's waived, like many of the issues on this appeal. Alternatively, that error is harmless in light of the examination of the entire case, the fact that this is an interpleader defendants arguing over a sum that really it was undisputed the creditor was entitled to if they had just come forward with the estoppel letter and provided the appropriate documentation. For those reasons, this court should affirm the entry of summary judgment and the distribution of funds as ordered by the trial court. Thank you.
Thank you. Mr. Montanez, you have 5 minutes, sir.
Sir, your microphone's muted.
Mr. Montanez? Yeah, there we go. Okay.
Yes, just in response, I believe that the trial court improperly shifted the burden to the non-moving party in a motion for summary judgment in this case. The court saw the evidence that my clients had submitted and asked for more, and my clients did submit more. They submitted timesheets and they submitted receipts regarding costs that were paid. But the court, I believe, improperly was weighing evidence at the summary judgment stage, something which should have been reserved for trial. And I'd also like to point out that there
well, hang on, Mr. Montanez. We have a new summary judgment standard now, right?
Yes, we do, but I don't believe that was in that wasn't
in play at that time, right?
Yes. Yes.
But how about on our review? It's in play now.
Well, I believe the court would have to apply the standard that was in place at the time that the hearing took place, because that's what the parties were operating under at that time.
I won't let you off the hook, Ms. Montanez. Suppose we agreed with you, reversed, we remanded, and then for further proceedings, and the next proceeding is another motion for summary judgment, and you got the same evidence. With the new standard, how do you win?
With the new standard, I believe my client would have to submit additional evidence to support their claims before the next hearing on the motion for summary judgment.
All right.
I'd also like to point out that the court in this case did not disallow any of my client's affidavits. That's not part of the judge's findings. It's not part of the transcript. So I believe that the affidavits were properly considered. Furthermore, the affidavits were signed by Ronald Gillespie. The affidavit said that he had personal knowledge as to the matters alleged therein. And it also it also identifies Mr. Gillespie as the beneficiary of the trust. For all those reasons, we believe that the lower court's decision should be reversed and remanded for further proceedings. And thank you. Thanks.
Okay. Thank you both very much. Ms. Newell, you were here on 2 complicated cases today. You were amazing that you were totally on top of both those cases and clearly had a command of the record.